Good day, Fiscal, and good day, everyone. Today, we delve into a compelling case that has captured the attention of the public and the legal professionals. We are discussing the estate shock, a riveting scenario where a man diagnosed with dementia made a controversial decision regarding his estate. Imagine this: a wealthy individual, despite suffering from dementia, appoints his mistress as the executor of his will. This unusual choice sets the stage for this case. Let's dive deeper into how this case unfolds. The facts, the arguments of the parties, the evidence presented, the prayer, and the group's position and conclusion. So let's go to the nature of this case. This is a special proceeding focusing on a petition for the probate of Juan Salvador's will initiated by the executor, Concepcion Claro. Interestingly, there is opposition to the allowance of the will. The challengers include Felicidad, who is the wife of the deceased, along with Maui and Bogart Salvador, his legitimate children. The family dynamics and legal intricacies make this a particularly compelling case to study. This brings to light the various disputes that can arise in the probate of a will. Let's now look at the key parties involved. On one side, we have Concepcion Claro, serving as the executrix. She is appointed to manage the estate in question. On the opposing side, we find Felicidad Carpio Salvador, who is the wife of the deceased Juan Salvador. Alongside her are their two children. Let's continue by identifying the appropriate venue for the legal proceedings following Juan Salvador's passing. In line with Rule 73, Section 1 of the Rules of Court, the case will be under the Regional Trial Court of Bacolod City. This venue is based on the fact that Juan Salvador resided in this province at the time of his death. This ensures that the proceedings are conducted in a location that was closely connected to him, streamlining the process of the parties involved. Statement of facts. Let's now focus on the petitioner's version. Juan Salvador passed away on December 26, 2023 in Bacolod City, and he is survived, as the petitioner alleged, by his legal wife, Felicidad Carpio Salvador, and their two children, both of whom are legitimate. Additionally, Juan had a minor child named Bo with Concepcion. It's important to note that before his passing, Juan executed a notarial will, which has become a point of contention and is central to this case. This will is crucial as it outlines the distribution of his estate, which we will examine next. The notarial will in question clearly acknowledges Bo Salvador, the testator's son, born on January 1, 2018. Notably, the will bequeaths the entire free disposable portion of the estate solely to him. Now, let's delve into the steps taken by Concepcion Claro. She was designated as the executrix in the will of Juan Salvador. Recognizing her responsibilities, Concepcion formally accepted her role by filing a petition with the RTC of Bacolod City on January 8, 2024. This petition was not just a formality, it was her way of officially taking on the trust assigned to her in Juan Salvador's will. The narrative progresses as the legitimate heirs step forward. This is pivotal in our discussion. The heirs challenge the proceedings. To counter the opposition, the petitioner meticulously demonstrates compliance with all procedural requirements, including notice and publication, which are crucial in validating the legal process. Following this, the petitioner brings forward the three attesting witnesses and the notary public. These individuals play a key role as they testify to the testator's mental capacity and freedom of action at the time that the will was executed. On the opposite side, let's explore the oppositor's version of events. They claim that Juan Salvador died on December 26, 2023 in Bacolod City, and he is survived by his wife Felicidad and their two children. It's important to note that at the time that Juan executed his notarial will, he had been diagnosed with dementia. He was under medical treatment for symptoms including memory loss and confusion with prescriptions, and these were provided by his physician, Dr. Strange Lee. This medical condition is central to the contestation of the will, raising questions about one's capacity to make such decisions at that time. The oppositors argue that one's mental incapacity is evident from his inability to recall even the most personal details, specifically his children's names and faces, and this significant memory lapse, according to them, clearly indicates that Juan was suffering from dementia. Consequently, they assert that when Juan executed his will, he was not in a state of sound and disposing mind, essential for making such legal decisions. This point is crucial for understanding the challenges against the validity of the will. Let's delve into two critical issues regarding the case at hand. First, we need to address the mental capacity of Juan Salvador at the time that he executed his will. The central question here is, was he fully aware and capable of understanding the implications of his actions when he made that will? Moving on to the second issue, it concerns the legality of the notarial will itself, executed on December 1, 2022. We must examine whether this document meets all the formal requirements set forth by law to be considered valid and therefore enforceable by the court. Now, let's look at the arguments of each party. As for the petitioner's main submission is that the will should be probated on the ground that it was made by the testator when he was in his sound and disposing mind, and that the will itself complies with the formal and substantial requirements of the law. As for the oppositor, on the other hand, the oppositor submits that the will should not be probated because the testator was mentally incapable of making the will at the time of its execution. As for the evidence, the pieces of evidence presented by the petitioner were the following. As for the testimonial evidence, she submitted the judicial affidavits of Sofia Trece, Maria, and Superiano. These are the instrumental witnesses to the will. She also submitted the judicial affidavit of Attorney Ben Gravador, the notary public. As for the documentary evidence, she submitted a copy of the notarial will of Juan Salvador, the death certificate, and the birth certificate of Bo Salvador to identify minor heir who is represented by the petitioner. On the other hand, the oppositor submits the following pieces of evidence. For the testimonial evidence, she submits the judicial affidavit of the attending psychiatrist to establish the decedent's acts as reflective of his mental status. For the documentary evidence, the psychological assessment of Juan Salvador to show his mental state, as well as his medical prescriptions. The prayer of each party. The petitioner prays for the probate of the notarial will of Juan Salvador. On the other hand, the oppositor prays that the estate should be divided according to the rules on intestate succession, and that the notarial will be disallowed. If you were the judge of this case, who will win? Will it be the petitioner, the mistress executrix, or the oppositor, the wife, and their legitimate children? I will now give the time to my group mates for the group's position, conclusion, and defense.